Good day, class. We'll start our discussion today on the right to good and healthy environment in Nigeria. Now, the first thing you need to note is that the right to good and healthy environment is actually an aspect of the right to health. Now, the right to good and healthy environment is therefore based on the concept of human right. This emphasizes that one of the essence this emphasizes that one of the essence of environmental protection is to protect the lives of human beings rather than concentrating too much on the environment rather than concentrating too much on the environment itself. So the right has always been recognized as a prerequisite, actually, to the enjoyment of other fundamental human rights. So the right to good and healthy environment is referred to as environmental right. Those are the rights we call environmental rights. So environmental rights is actually the application of human rights to the context of environmental protection. So environmental rights is the application of human rights to the context of environmental protection. Now, scholars have emphasized that human rights cannot be enjoyed except the environment is protected. So they have said that human rights cannot be protected and reasonably enjoyed without the protection of the environment where they are to enjoy those rights, where humans are to enjoy those rights. If you don't protect that environment, then the other rights would not be fulfilled. So the proof of the relationship between the environment and human rights can be seen from, for example, the effect of the environment. Now, environmental risk and denigration, for example, on the other on a whole, if on a large scale, for example, affects the enjoyment of human rights. Let's say if the environment is polluted, the right to health will be gravely affected. For example, if water is polluted, the right to good drinkable water, the right to good food will also be infringed upon. So whether we like it or not, you cannot discuss the right to good and environmental protection without relating it to other fundamental human rights. So the enjoyment of other human rights is actually based on the environment. So for you to say you are protecting human rights, you must also protect the environment in which these rights are supposed to be enjoyed. So this is what we refer to as the environmental right. Now let's go to the constitutional provisions on environmental rights in Nigeria. We know there's an environmental right, which is the right to good and healthy environment. Now let's look at the position of our constitution. Now, the 1999 constitution did not expressly make provisions for the right to good and healthy environment. It only says that the states have the obligation to protect and improve the environment in Nigeria. So it's more of an objection. So it creates it's an environmental objective of the government to do so. So there's an environmental objective of the government to protect the environment, to improve and protect the environment, according to section 20 of the constitution. But it's, as much as it makes provisions for that environmental objective, it says that it is non-justiciable. So by virtue of section 6, subsection C of the constitution, as much as there's an environmental objective to protect the environment, it says that it is still not justiciable. So it means that the government do not have it as an obligatory, it's merely a directory. So if they decide not to protect the environment, it means that you don't have environmental right. So it is not enforceable in court. That's what it means. The provisions cannot be enforceable in court. Now, but victims of environmental rights have always relied on the provisions of the African Charter on Human and People's Rights. You know that right is domesticated in Nigeria. So according to Article 24 of that charter, it makes provisions for right to environmental good and healthy environment. It talks about the right to a satisfactory environment favorable to the development of citizens. So courts in so many cases have applied the provisions of Article 24 of the African Charter to environmental rights and holding that people have the right to have environmental rights, the right to good and healthy environment. Now, for example, in the case I gave you in the note, the case of Bemre and Shell Petroleum Development, the court actually applied Article 24, where the environmental rights of the citizens coupled with the right to life and right to health were infringed. The court held that applied Article 24 to hold that they have the right to good and healthy environment. As much as we have reliance on this African Charter, but it's still very important for the ground norm to make provisions as it has provided for other rights, for environmental rights. It's very important because it means that tentatively, if the African Charter, for example, as it's in any other law, like any other law in Nigeria, is repealed, what happens? It means that the foundation upon which we based our environmental right on would vanish forever. So it's very important that as much as we are relying on the African Charter, the Constitution should take steps, should be taken by the government to make sure that the right to good and healthy environment is actually made a right under our Constitution. Now let's go to public health laws in Nigeria. Now, one thing you need to note is that public health laws in Nigeria, the legal framework for the provisions of public health in Nigeria can be deduced from legislations on health and safety generally, such as the public health laws that you have in different states at the state level, environmental sanitation laws for states, all states virtually have it, the Factory Act, other subsidiary legislation on health and safety. So any legislation you find on health and safety, public health and safety, all come under the legal framework for the public health in Nigeria. Now let's start by discussing just a few of them. Public health law. Now, initially, the first major health law that we had was the Public Health Ordinance of 1917. Thereafter, we had the Public Health Law, Chapter 109 of 1963. Now, all states have their public health law at the state level, because the Public Health Law of 1963 actually became the public health legislation of the Federal Capital Territory, and so other states had to enact their own public health laws at the state level. Now we'll look at virtually all the states have the public health laws. Now, for the purpose of this discussion, we'll look at the public health law of Lagos State. Actually, Section 6 actually makes provisions for various statutory nuisances which will amount to prejudice to the public health of a particular community, and it states various acts that will amount to statutory nuisance, which will amount to a prejudice to the public health of Nigeria or of the state. So you can look at that. It talks about premises that are in condition that are injurious to health, premises that are in dark, premises that are not well ventilated, where you have ditch or pools that are or silage that are in state or condition that are injurious to health, and all that. So it makes provisions for statutory nuisances, which talks about situations that could be prejudicial to the health of the people in the state. Also, the Criminal Code has provisions on public health from section 243 to 248, actually deals with offenses against public health. You can also look at, and the third one is environmental sanitation law. Also have different provisions on public health, where it talks about lack of healthy environment, the dumping of and discharge of waste and refuses, public drains, water, and where you dispose refuses. It actually makes them issues of public health and are prescribed punishment for those actions. You can look at section 4 and section 5 subsection 2 of the environmental sanitation law of Lagos State. You can also see section 13 and 16 of the environmental sanitation law of Lagos State. So you can also look at the case of Attorney General and Todd Italy. In that case, the court held that even if you have a vacant land, you have the duty to make sure that that land does not constitute statutory or public nuisance that will be injurious to the public health. You have that duty. Also, the fourth thing we need to look at is food contamination and drug control. We have laws that have been put in place to ensure that food are not contaminated, to avoid food poisoning, and even drugs that people use are not fake and adulterated. So you can look at the Food and Drugs Act, Poison and Pharmacy Act, Drugs Related Products Registration Decree, Counterfeit and Fake Drugs and Unwholesome Processed Foods Miscellaneous Provisions Decree, and all other subsidiary registrations that actually has to do with the regulation of food control and also drug control. Now, the agency that actually manages this area of public health is actually NAFDAC, which I'm sure you are aware of. Now, let's look at animal disease control, because we know that most of the major source of our protein actually comes from animals. Poultry, fishery, and all that. Laws have been put in place to ensure that the animals that we eat are fit for consumption. To ensure that they are fit for consumption by the time they are being sold to the public. So we have the Animal Disease Control Act from section 1 to 3 states the condition in which meats that will be put out for sale, poultry, fish, and other that will put out for sale, that it must be of good quality and it must be inspected before such can be put out for public sale. We also have epidemiological control. So it talks about where there's an outbreak of epidemic. What are the things that must be put in place? We have, for example, we have had occurrences of epidemic outbreak in Nigeria. The most recent one that you will be able to relate with, we have Ebola. Now, the current one that we're facing, the COVID-19, are all epidemiological diseases which the government are supposed to prevent. So in Nigeria, the laws on control of communicable diseases as an aspect of public health are public health laws that prohibit statutory nuisances that are prejudicial to the health or as discussed above. So the public health law, the environmental sanitation law, and all that are also laws that apply to epidemiological control. Also occupational health and safety at work, because we know that there are occupational diseases that expose people that work in a particular profession to certain kind of diseases. Now, laws have been put in place to ensure that their safety, to protect their health while they work. So we have the Factories Act, which has made provisions for occupational health and safety standards that employers must put in place in order to safeguard the health of their workers as much as possible, and then to put in some health standards for the benefit of their employees. For example, like adequate ventilation premises, adequate ventilation of premises, sufficient lighting, safety guards and gadgets depending on the kind of nature of the job. They have to put some safety gadgets in place to help to guard the employees against accident and all other things that might pose as hazard depending on the kind of occupation we're talking about. Thank you very much. We have come to the end of our discussion. So you have to download this video, read the note I sent earlier, and send in your questions. So at my next class, we're going to resolve those questions. Thank you very much. Please stay safe.